So just be aware that it's not just do it informally, but just be aware that this is a written consent, this is in writing consent. Moving on without other...
Well, let me tell you this, though.
Yep.
I have also seen people, and this was maybe back a little bit more in the day, where they would get, when they signed up the case, the complete authority to make decisions regarding settling the case. They do all the negotiations. The client doesn't know anything about that. They do all negotiations. They accept. I've seen it. I've seen them. And in fact, let me tell you one quick story. Weirdly, your mother was the judge on this trial. I have this woman. She is the best witness I've ever seen. And I was a fairly young lawyer. This woman is a fantastic witness. And while her case might normally have been worth, and this was big money back then, $200,000, I had evaluated it higher because this woman was the best witness I've ever seen in my life. And I loved her. And I thought, if I love her, and I'm kind of a skeptic, everybody else is going to love her. So we offered it, didn't take it, went up, finally got to the top, offered way more than the case was worth. So we start to try. I'm like, okay. So I remember the judges even said to me, because this is a big high-profile attorney on the other side, and I was a relatively young lawyer, and she said, Debbie, you know this is so-and-so, and he's a really good attorney. And I didn't know what to say, so I said, well, Judge, the bigger they are, the harder they fall. And she laughed, and that was the end of that. So the woman she flew in. She was there for trial. We were waiting on a jury, and she came over because, again, this is the sweetest woman on earth. And she said, I'm so sorry we have to be here for this. I said, I'm so sorry we couldn't settle it. And I really had hoped, we could do that. And he's standing right here. And she says, settle it? I didn't know you all made an offer. What do you say? He's right here. Didn't call him right out. So I just looked at him and went, what do you do? And she took him, and they walked over to the side, and she came back to me, and she said, we're settled. She flew. I won't tell you where she flew from because it might give something away, but she flew for at least 8 hours to get here. 2 years had passed since we made the offer. They'd taken all their doctor's depositions. Everything's going to come out of the offer. It was crazy.
It wasted money.
And everybody in here would be shocked to hear who it was. And wasted money, which was money gone.
Yeah. You got to...
It's weird.
You want to be communicating those settlement offers to the client. You want to do it in writing. You want to be, because then when you walk in, you get a defense verdict, and then they find out there's money on the table later, then the plaintiff's lawyer is in real trouble.
Right.
If you don't settle your own legal mal case in the release, and then did you know, and don't have sexual relations with a client. But here's my favorite part of this rule is K. So K says, if you're associating a firm, you're prohibited from doing 1.8 A through I, but not J. So they accept the sex with the client. Your partner can do that. So I think that's from that LA law show.
Well, I think maybe it's if you're representing your partner's wife. He could have sex with her. You just couldn't.
So do we? I'm getting uncomfortable. So there's no Chinese wall for these conflicts in Missouri. There is no Chinese wall while lawyers are associated with firm. But lawyers move firms all the time in terms of these conflicts on other sides and stuff. And I see firms effectively erecting Chinese walls from time to time. But there is none of note. Joe?
I think that's a drafting error, James, a late addition to the rule. So they moved the old J down to K.
Oh, is that right? Oh, that makes sense.
I agree with you.
That makes sense.
Don't do it if you're doing that. All right, let's
go. So I got
through.
one thing to point out on this page before we go. I got a call from a young lawyer. And he said, I have a situation I need to talk to somebody about. I don't know who else to call you. Why he called me, I don't know. But he called me, and he said, what do I do? He did not have sex with his client. He had sex with the plaintiff. His client was the defendant. So he had sex with his client's wife in a lawsuit against her.
And what was your advice?
Well, I said, well, there's no rule against it, so don't worry. I didn't.
It's a 4.2 violation.
I did not say that. I said, call and self-report. And he did. He called and self-report. It all worked out fine. I mean, it was...
Let's keep going. We're going to go...
You want to go straight?
Well, no, do you guys want to take a break or you want us to finish ethics? Does people want a break? Finish?
Okay.
If anybody needs to use the restroom, please do at your leisure, but we're going to cruise on through and get to happy hour downstairs in the rendezvous room. Debbie's buying. She doesn't know it. No, I'm buying. Declining or terminating representation. I'm going to go through the comments to the rule. I'm going to skip that, and we can talk about that. But the client can fire the lawyer at any time with or without cause, and then you can see the comment to the rule. The lawyer may withdraw if the client refuses to abide by the terms of the agreement relating to the representation, fees, etc. The lawyer has to take reasonable steps to mitigate the consequences to the client. So I'm going to give you my handy-dandy if the client fires you and then if you fire the client rules. If the client fires you, the law says from the plaintiff's side that you get the quantum merit value of your work. This often means your hourly fee, but can be measured in other ways. Many smart lawyers do not assert that because you're inviting an ethics complaint, especially if you haven't done a lot of work and it's early on in the case. But if you have done real work to advance the case, you've done all of it, the client fires you, and 2 days later they call and get the same offer, and they try to axe you out of your fee, then you may want to make a claim for attorney's fees in that case. Assert your lien in a reasonable attorney's fee. There's 2 attorney lien statutes. I'm going to go into this in just a second. So if you're fired, you can do a letter to the insurance company saying, listen, I've been terminated. I'm maintaining a lien for my expenses I advanced in the case. And then the question is what you want to do. That's typically done. The question is, what do you want to do with your fee? If you don't know what you want to do yet, say, I'm reserving what I'm going to say about my fee. If it's early on in the case, and most of the time I say, I'm not making any lien for any fee. Let them go find another lawyer. The case will be hard enough to settle as it is. Good luck to you. And then I hope to get my expenses back down the road. But you need to be careful. But then again, if you've done a ton of work and they're improvidently getting rid of you and trying to play a game with your fee, then sometimes you can. It's the client's file. It ain't your file.
That's right.
Don't keep the file. Give the file to the client. Copy whatever you want. There is some authority about medical records. If you pay for the medical records, you get to keep them and stuff. There's some law that says that give them the medical records. It's not worth the ethics complaint for the $400 or $500. Send a lien to Debbie or the other lawyer, the insurance company, saying, I have this much in expenses. Here they are. If you ever settle the case, pay me my expenses. Only release your lien for expenses at that time. You fire the client. What do you do when you want to fire the client? And Debbie, I'm sorry, jump in too.
No, I'm good. I've got a couple things I want to ask you once you finish this slide.
Give notice and reasons for the termination. Give them time to get a new lawyer. If you're in litigation and you file a motion to withdraw, never ever say why you're doing it. It's
That's
a
right.
one-line thing.
Say that again.
Never ever say why lawyers do this all the time. This is why I'm getting out. Well, you just breached the attorney-client privilege. The attorney-client privilege exists regardless of how crazy your client is or whether or not you still represent it.
You can say something about yourself. I'm sick, I'm whatever, I'm moving, I'm retiring. You can't say anything about your client.
Yeah, you say you're doing it. And then if the client, I've had this happen, I think twice, where the client comes in and gives all these reasons why that they object to it. And then I just get up and I say, I think they just proved that I have a conflict to continue to represent. They say this or that or the other thing. Don't say in the motion. You always ask the court to give them 30 days to get a new lawyer, proceed pro se. You want to give them a chance to do that. If you're terminating them, you also always send them a letter, and if you're pre-suit, you need to tell them what the statute of limitations is for their claim. And you need to strongly encourage you to seek the services of another lawyer. Go find another lawyer. Here's the statute of limitations. If you don't know the statute of limitations, you can't just vacate on it. You have to give them your best. You say, listen, the Missouri law would say you have a 2-year statute of limitations for medical malpractice. It's 3 years from wrongful death, but there's an exception for continuing care by the doctor who committed malpractice. Many courts would think that statute is extended, but there's a risk there, okay? Or sometimes, 2 years versus 5 years. In Illinois, you got a 2-year statute on a PI, but if it's underinsured, you may have a year to put them on notice. So you need to give them that advice. The other thing is don't terminate a client 2 weeks before the statute's going to run and say, go find another lawyer. You're going to get sued, okay? But you also aren't going to file a lawsuit for them. What do? You write a petition for them, you put their name on it, you don't enter your appearance, you give them the petition, and you say, and even if it's a med mal, whatever it is, you protect yourself. Say, here's your petition, you want me to file it for you? Or for you as a pro se person, anybody can go file a lawsuit, or do you want me to just give this to you and you go do it? Here's the address of the courthouse, 7900 Carondelet, the filing fee is $220, go do it yourself. You need to protect yourself for that. But don't do that. Get rid of cases well before the statute is going to run, because it's only fair that they get another lawyer to look at it.
If you have filed suit, tell them every deadline that might be coming up. Tell them what you think they need to do, in the next 90, 120 days, even though they only have 30 to get a lawyer. Any deadlines, don't let them, but bottom line is, leave your client better than where you found them, to the extent you can. And sometimes we're really mad. Sometimes we're really mad about why we're trying to get rid of this client. And all you really want to do is shut the door and get them out of there. But you cannot do that. And if you are in a firm and you can't be objective about it, let somebody else do that withdrawal process, because they're not personally invested in it.
What else you got?
I like
Go
this.
ahead. I've skipped
no,
over
I
your
want
notes.
you to tell this.
Oh, I sometimes say, I'll charge no fee for my legal service. If you do recover from the liable party, then I ask you repay me for my out-of-pocket expenses. That's my typical deal. And that's what I always do. Even if I've done work, you know what? Let them go. Let them go. And bad cases usually get worse. If your relationship with your client is devolving and they're not taking your advice, that's when you get out.
Do any of you assert a lien, or all of you assert a lien? What do you think about that, asserting a lien once you're out of a case? Yeah.
I've almost never done it. I've never had that situation, but when I did, 3 or 4 years later, I got a nice check from the sitting lawyer. So.
Yeah, that's good. Anybody else?
I just had to babysit some that I inherited when I joined the firm. From what I can tell based on reviewing the files, it sounds like some of the clients were pretty cantankerous and difficult to deal with. And I think from a certain perspective, when you put a lot of time and effort and obtain a favorable offer, and then the client, kind of breaks down, I think it's okay. We have a case right now. Policy in this case, the client has astronomical damages in the state minimum policy. We negotiate all our liens down and just still don't think it's enough. And it's just like we're cutting our fees.
Yeah.
To a certain percent, and you still don't want to take our advice. I'm not sure what you want to do with it, but here you go. We'll just retain our lien.
Yeah.
It depends. I've had a case where a client fired me 2 months before mediation when it was already set. Mediation was already set. Then went to another lawyer who took the case. And I did ask for a fee in that.
Well, you'd done most of it, yeah.
Hey, Debbie, first 12 years of my practice, I worked in a defense firm and was in the habit of keeping hourly time. So on those rare occasions when I get terminated, if I've kept very careful time, I will consider asserting. I would probably have trouble asserting a lien if I couldn't really carefully document my time.
Yeah.
Because I'm in the habit of doing that.
Yeah.
I can just push a button and pull a printout, and I can document very itemized 25 hours of work, and if I got that, I'm going to stick by that.
That's smart. That's smart. Plus, that gives the judge somewhere to start if he's doing a pro rata determination of fees.
And the associates who work with me, when I had certain when I had associates, they were required to, we had a special feature for this phone. You push feature 77, and it'll tell you how long you've been on the phone.
Oh.
And they would have been doing that,
Yeah, that's smart.
Thanks, Salif.
It was just a habit left over from defense work, and I find it's much easier to, I handle read versus read, we'll get on the weeds on that, but it's a lot easier to get your fees when you can show clearly what you've done.
Yeah.
It's a good point. It's different if you're doing hourly work versus contingency.
Yeah. In what you said, if you've worked up a...
All I do is contingent work, but I got that same habit.
You keep your hours, because
makes you efficient. I like those.
Well, you have a quantum merit claim if you
Yeah.
can do that. There's a lot of cases on that.
I had a lot of weird cases, and some of them are plaintiff's cases, but if I've got a plaintiff's case, it's a piece of crap that nobody else wanted, or the other attorney did some work on it and realized this is a dog and it came to me. So if somebody was on a case that I had, and they waive their fee, I always make sure they get the next referral I have, because there's so many cases I can't take. So, you got to make things, you've got to, what comes around goes around.
I'm going to keep, sorry?
Karma.
Yes, exactly.
Go ahead, keep going.
I'm going to keep pushing
Yeah,
through this.
do
Is that
it.
all right?
Yeah.
Contingency fee, it's got to be in writing. You have to say what you're going to do with expenses, whether or not you lose. And you have to and then at the end of the case, you need to give a written statement. You need to do a settlement sheet setting out what happened to all of the money. And the fee has to be reasonable. You can't do it in criminal or divorce cases. You can divide fees under Rule 1.5E. If you refer a case to another lawyer or you get a case referred to you, you don't both have to work on it if you both assume joint responsibility, but that also means that you can't send a case to another lawyer and have them blow the statute and then limitations, and then you're on the hook for the malpractice as well. So you want to keep track of that and communicate that with your referral partners about what's happening in cases. And then under F, you have to consciously consider, for alliteration lovers, you have to consciously consider a fee dispute resolution program if you have a fee dispute between a lawyer and a client, and you should, and there's a free fee dispute resolution service with both the Missouri and Illinois bars. Anything on that?
I didn't realize that the client had to be aware of the fee.
Oh, yeah. So if you refer a case or you get a case referred to you, you don't have to do a new fee agreement with the client. You can work on the other lawyer's fee agreement who signed up the client. They do it, then they ask you to come in and help. You come in and help. You just do a letter to the client that says, "Listen, I'm working with Joe on a case or Fernando on a case, and that we're going to work under the fee agreement you already had with the prior lawyer," as long as it's confirmed in writing. You can't orally do it, though. You can't just do a case and orally do it. You have to confirm it in writing, but you don't need to do the details. I'm always transparent with that. I advise the client what the split is and who's paying the expenses and what's going on from there so that they know what the deal is. 2 attorney lien statutes. There's a special lien statute just for contingency fees. And they're set out there. Enforcing attorney's lien, there's a lot of law on this. This is the case I cited here, the Plaza Shoe case. You can either resolve an attorney's lien in a pending case, or you can or the lawyer can file a separate case. The case is over, you think they're done, the client didn't tell you that he had a prior lawyer, that other prior lawyer can do a separate case in there. And so I know most insurance companies are going to keep track of prior lawyers and get lien waivers from prior counsel, or they will have the client protect and indemnify for any other fees. There's a lot about asserting the attorney's lien. There's different requiremements of it. They're pretty strong. The statute's pretty strong. I mean, lawyers wrote the law, so the lawyers are strongly protecting their liens. And it's a really old statute there. We mention it. Anything else before I go to motion for sanctions?
I just want to make sure you all understand that it's not just a lien letter we're looking for. If anybody appears with you in a lawsuit, not a member of your firm, or files the suit and then you take over, that person automatically has a lien in Missouri. So we mark those liens. Sometimes it's 3 or 4 different attorneys before they get the final one. And they may not be asserting a lien, but the insurance company is going to carry that as a lien just because they signed their name to the file and filed suit.
And if you have a case with other lawyers, call and resolve those old liens. Somebody else had the case for a while, do that. Pick up the phone and call them. Don't just hopefully they won't go away. I mean, you want to call up that other lawyer, and if the lawyer say, you know what, I had him for 3 weeks, I don't care. But if the lawyer wants to be persnickety about an asserted lien, you want to know on the front end, because you need to tell your client that, hey, you had so-and-so for 6 months, and then you came to me, they're going to assert a lien. Fair or not fair, that's what it is, because you want to know that now, because if you're in litigation, you want to do a motion to adjudicate lien in front of the judge at that time before that case is gone, because you have a duty to that client. You go in front of the judge and said, hey, they had so-and-so for 6 months, he's asserting a lien, I think it's bogus, but here's what it is, and then you get a final court order adjudicating that lien, so they're done and they're gone.
Is that over? That's giving a little
Oh,
feedback.
I'm sorry. Thank you. Does that make sense? Any questions about that?
Here's a question.
Yep.
If it's kind of being asserted under that quantum merit
Yep.
theory, like, what would your recommendation be? Because, I mean, especially if it's pre-suit, where, like,
You're asserting or you're defending against it?
either or, like, you know, either a black box, I'm asserting it under quantum merit, I don't necessarily want to attach a precise value, or I inherit a case where the other lawyer won't.
Assert a precise value if you're doing it, because you want to be transparent and clear with your former client and say, listen, I did 20 hours of work on this case. I'm going to charge
Gone
you
from
for
up there.
I'm going to charge you for 5. Here, let me.
Those turn off.
I'll go back to this one.
Okay.
You're going to say.
There, much better.
So you want to say, you want to tell them what you charge them for, and you want to be transparent with that client. I charge you for 20 hours of work. But I want you. I did 20 hours of work, but I want you to pay me for 5. Something fair to them to get rid of it. Or sometimes it's not fair. It's getting that early money is easy. It's getting that. It's getting that second half of the money that's hard. So there are, you can get that early. I can get a $10,000 offer in a $50,000 case really easy. But should I get a fee on that? No. It's getting that from 10 to 50. That's the rub in the case. Motion for sanctions. Do you file motions for sanctions against lawyers when they dilly-dally in discovery?
So the last ends of court meeting, I don't see anybody in here who's in the ends of court, but if you are, let me know. Last meeting we had in April, this was the topic. We had a ton of judges there, and they did this presentation that talked about what you should do in trying to refrain from motions for sanctions. And I was at a table with all judges, and Judge Draper leaned over to me and said, do you file motions for sanctions? And I said, I think I remember one in my career. And since that day in April, there have been 4 filed. So I think there's an increase. But no, I don't usually file motions for sanctions. I have one associate who, if I don't catch him, if I don't see it before it happens, he might file a motion for sanctions instead of calling it a motion to compel. But it really is a motion to compel. But no, we generally are not big motion people, motion sanctions people, at least.
I generally don't either. You got to give people time to get stuff done. I have had some. I had a motion where I had a doctor. I proved in his deposition that he had altered his records and redone his records in a med mal case, and it wasn't produced to me to a depot, and I had already done a bunch of work. And so I did a motion for sanctions. I went and I won it. I got the sanctions order, but then I didn't collect on it, and I left it hanging there until I settled the case. At a request from the lawyer's boss at a different firm. So I very rarely do it, but I've had cases where I'm trying a case and they produce thousands of pages of documents to me during trial and that kind of stuff. So that's bogus.
That's ridiculous.
But then the question is, what's the fashioning the remedy? And judges are loath. I'm not worried about the $200 or $300 an hour for the work that it does, but the question is, what do you do do you strike pleadings? What do you do? there used to be a lot of gamesmanship over in Illinois with striking pleadings and doing some of that stuff, and that's not gonna hold water in Missouri. There was a case out of the county where a $25,000 sanction was ordered for, it's a divorce case. I know the judge who did it, where the ex-husband still had access to the wife's email and was reading all the attorney-client. And anyway, the Court of Appeals reversed that and said it was not well granted. I thought that would be a good sanction. That's bogus. You shouldn't do that. So, but I really don't do that. But the teeth in Rule 6101, which we quote here, there's a lot of stuff you can do. But you can do other stuff. You can, what about request for admissions? If you never, you don't, if the defendant doesn't answer a request for admissions, you're going to go to trial, you think you got it all admitted, they come in with a late denial of all the requests for admissions and a motion for leave to file them out of time. That's completely BS, but it happens.
What I do on those, if somebody did not answer request for admissions, is I file a motion to deem them answered before we get that far down the line.
And then is a judge going to give them leave to answer out of time?
Yeah, but
Almost
at least I
every
know it
time?
early enough.
Or also, what about when they don't answer summary judgment, statement of uncontroverted material facts?
Well, I don't think that's sanctions. I just think,
It's just admitted. Do judges usually let them answer them out of time?
if they affirmatively ask, but not while you're at hearing.
How about in the audience? Who here asks for sanctions or makes that part of their practice? Genevieve Fikes, nice.
Times when I've done it successfully or when there's a corporate rep totally unprepared, different materials, and usually the sanction that I'm asking for is just to depose them again, just because you need that information for your case. So usually if I'm filing a motion for sanctions, it's because I literally need the information to make my case progress, and if I don't do that, then I have no other remedy really.
That's smart.
I don't think that's improper at all. I probably would call it a motion to continue the deposition of the corporate rep instead of motion for sanctions, but I don't think that's improper at all.
Yeah, if you're tailoring the remedy to be able to prove your case or address the problem of the defendant, and you'll have that all the time. The corporate rep will come, they'll testify on 3 of the 17 things you got. Well, they just need to produce someone else.
Right.
It's not necessarily
Right.
a sanctions motion. Excellent. All right. We can do, and we've been going about 1 hour and 25 minutes, so I'm going to try to go another 15 or 20 minutes, okay? Is that okay? So everybody can get their 2 hours of ethics and we
I
can.
think if we go till close to 20 till, that we are,
You're
they've 2
good to go?
rounds. Mhm.
All right. Do we got enough to talk about here?
Oh, yeah.
What about, so do you ever run into issues on the defense side about advertising or communicating about a lawyer's services or that kind of stuff?
Very, very, very little.
Do you
Yeah,
ever,
Very seldom.
do you ever run into plaintiffs or plaintiffs' lawyers who you catch or find out that they solicited the case?
I don't care. I mean, isn't that terrible? I don't care. There have been so many, think back 20 years. There have been so many, where you knew they were getting police reports or ambulance reports and probably paying somebody for them. Whatever, I don't care. Somebody's going to get it.
That's been in the news recently.
Yeah.
We saw
But
that
that's been going on for years.
the
We're just
police
now looking
officer
at
and the chiropractor
Yeah.
were charged.
Yeah. So yes, I have seen things where I think attorneys solicited, but and I think that's kind of none of my business. I guess it's my business as an attorney if I think it's improper solicitation, but I don't know the details of how they got their case.
All right, so you have to balance. You have to think about these rules in context of the marketing thing we heard early today too, and in the social media world as well. So this 7.1, you can't make false or misleading communication. You can't say I'm the greatest trial lawyer in the world, or you can't compare I'm a much better trial lawyer than so and so, that kind of stuff. You can't advertise for cases that you don't take and all you're doing is referring to people. You can't do paid testimonials without telling people that that's what you're doing. You can't have George Foreman hawking cases for you when you don't say that it's true. You can't say that if you're doing contingency fee work, you have to say that the client may be responsible unless you're going to eat those costs, because you can go to trial, you can lose the case, and the judge can assess costs against them. And unless you're ready to stand up for that, you can't do that.
Do you
can't
see
solicit.
improper solicitation?
Yeah,
You do.
I can. I mean, yeah. And then, so that's Rule 8.3 is, does it rise to the level that you need to report it to the OCDC? If you think that another lawyer's behavior questions their ability to practice law or really challenges that, then you have a duty to send them to the OCDC on that. And it depends on the circumstances. I mean, if it's a casual thing, that's one thing. If it's overt, trying to steal your case, that's just not improper. There's a lot less of that than there used to be.
Yeah.
But there used to be a lot more than that, and it depends in the area of practice too. I think the OCDC well regulates this.
It's a
But you can't
compare.
give anything of value to a person for recommending the lawyer's services. You can't pay a chaser. They used to have, people would go chase cases
right.
for them. They have it investigators. People would have nurses at ERs that would hand out cards and all that kind of stuff. You can't do that. So you can't, if you know that someone was injured, you can't solicit them. You guys, you know the movie The Verdict, in the first scene when Paul Newman goes to a wake and he's handing out his card to try to get the wrongful death case.
Yeah.
You can't do that. What you can do is after 30 days, you can mail a letter to the prospective client's house with the advertising disclaimer on the bottom of your letter saying, do you need a lawyer? And there are lawyers that do that. And the tension there is, on the one hand, you're going to need to balance the tension between, you can't have lawyers out soliciting people. It makes us all look bad. But people on the other hand would say, well, you know what? Some people don't know that they need a lawyer, and there are evil insurance companies that are out there trying to pay $1,000 to get a release on a claim when the person has a broken back, and that's not fair either.
Yeah, it's a tough conundrum. You know, people always fight about whether or not we should be able to advertise. But I think Missouri, I mean, sometimes you see advertisements that you think are goofy, but not compared to other states. There is this advertisement, for example, and there are a bunch of these all over the country where people do this sort of thing, and I think this makes lawyers look bad. This is, you know, what we have is, I'm a lawyer, here's what I do for a living, I want to help my clients, I want to da-da-da-da. This is a guy, and he's going for a job, and he's waving to people as he passes, and they yell his name out. I think it was Glenn something. So, hey, Glenn, and he's like, hi, how are you? And he continues to run. Hi, how are you? Oh, hi, Glenn. Continues to go on, and you don't even know what he's doing. And then it pans out, and there's an ambulance in front of him that he is chasing. It is the most ridiculous ad I've ever seen in my life. And it talks about people who are hurt, call Glenn Lerner, or whatever his name is. And I saw that and thought, we don't do that kind of stuff here. We just, I mean, in my opinion, the perspective is, I'm a lawyer who does plaintiff's work. I want to get my word out to these people, let people know what I am, what I do, and provide a good service. That is embarrassing. You know, the other hand, that's embarrassing to lawyers. It gives us a bad
Well,
name.
then how about the newest thing I'm doing? I took out a bunch of ads on the ceiling of an ambulance. Is that improper?
No, because it's a client with a known need.
No, you can't do that. You're
I'm
soliciting.
kidding.
That's my most brilliant marketing move. All right, but let me ask you this.
That's awful.
Can I pay people or give an offer to people to like my Facebook page or to like my law firm?
You can
Under
ask them to.
7.2C.
Can't offer them anything.
No, I can't?
Cannot give anything of value.
Right.
Can I, but what if they're not recommending me? What if they're just liking my Burger Law Facebook page?
Same thing. I agree.
You think that's a recommendation? So this has been an interesting issue. Well, what about what about all these people that are advertising for cases when you Google search and then you call them and they're not a law firm, they're just signing them up and they're directing the ads and I get these emails every day from lawyer referral services. Is that unauthorized practice of law? And is that improperly soliciting cases? And are they paying to recommend my firm?
Yes.
All right. So interestingly, or not interestingly, there's a real the rules kind of really don't address this, and the comments to the rules haven't caught up with social media in many ways. So in 7.2C, it's interesting. If you look at the bottom of that, you can pay for advertising, you can pay for employees, agents, and vendors, you can pay someone to generate client leads, such as internet-based leads, A lawyer may pay the usual charges of a legal service or plan or loyal referral service. A lawyer may refer cases to another lawyer with the promise that the other professional will in turn send clients to the lawyer. And it says professional or lawyer. So it sounds to me like I can send cases to a chiropractor if he agrees to send them back to me. These are all in the comments to the Missouri rule. Now, what about the online legal marketing? So there's a number of states that have, and we have all the sites to these if you want them. None in Missouri, but it was New York, New Jersey, all this stuff. Genevieve Fikes did this for me. So these are all cited on this page about, so AVO had to end it because all these lawyers had all these ethics complaints where AVO would get the cases and stuff and then redirect them. So a lot of these LegalZoom, AVO, Rocket Lawyer, they were doing this, and lawyers who had these contracts with AVO got in a bunch of ethics problems. Some of them lost their tickets, I think, and they ended that line in 2018.
What were they doing? Because I'm on there, but I don't know what they do.
No, but so there's a difference between saying you're getting reviews, you're doing stuff, you're putting yourself out there. There's a difference between that and a non-law firm like AVO or LegalZoom taking a client, intaking it, and then referring it to you. So they will call you and say, I'll sell you 20 cases for $500 a piece. And so not only, and I've never done it, I don't do it. I was on AVO, I did ads for them one point where my ad would show up, and you can do that with super lawyers and other stuff. We have those, and you can buy ads, but it's an actual solicitation. So if you look personal injury lawyer St. Louis, which I only Google every day to see where I'm ranked. Right, so.
Now I have to Google it.
Do you Google it every day? No. But if you look at that now, it used to be the big, well SEO'd firms was there, and I've done a lot of work to get up there too. But now you have AVO, you have all these others, you have Justia, you have these other services, and these marketing firms have found that, we're just being flooded with them trying to take the cases, so it's crazy. So I've gotten cases where I've had friends. Tyson emailed me one time and said, I just called these people up. I pretended I was a client. They signed me up. About 3 weeks ago, I had a ClassAction.com person solicit me bragging about my own case, that $113 million verdict I got last year, and asking me if I'd go. So I signed up with them. I said this, and as if
they did it.
Oh yeah.
Yeah.
Oh,
so
yeah.
like if you,
and I'm like, that's my damn case.
You'll see that on websites of attorneys. Like they'll take a case. I've had this on some of mine, and they'll reprint the case as if it were their case, but they don't say that. It's just new case, like it's theirs.
Well, you can. Like if there's a big verdict or something, if Sean gets a big verdict, I think I can go put his big verdict or the news story on my website, and I can talk about it. And sometimes we use that, but yeah, you don't want to mislead them.
Yeah.
But they can't go sign these clients up and then send them to you and then you pay for them. But it happens all the time. I just don't know. It's tough for the OCDC to track. The company that did that in that example for the case that I had, I went and looked at them. They're a group of online. They're a bunch of marketers, and that's all they are. And so I gave them my name and my contact, and I was trying to figure out who they sold the lead to find out what was going on. Not any. I was just curious. It's happening all over, and it's a way to. And the problem is that the reason why this should be enforced, my editorial, is you never know who's going to get those cases and whether the lawyer they send those cases to is going to know what they're doing or not. It's a license for malpractice. The other thing is they'll multiple sell those leads. They'll sell that same lead to 20 other lawyers and try to get that money. Any questions about that? 7.2C, social media, how to be careful about that. Put this on your representation agreements.
Oh, yeah.
Because if you're going to do, I do these Facebook Live. I put a client on. I give them a settlement check. I turn on Facebook Live. I put it on. The things that the key things you want to put on the bottom of on your representation agreements are this. That way they get you can use their stuff socially. You want to say, I also often say that I agree to let them, they give me a power of attorney to endorse a settlement check rather than having them come up and sign the back of the settlement check, because then I put it in my trust account and then I issue them a check. Two good things to put on that. And you want to be clear in your contingency fee agreement about whether or not, if you lose the case, if they're responsible for the expenses. One way or the other, you need to tell them that. And you need to stick to it and never, ever not comply with that.
Do you all have what you consider to be satisfactorily prepared representation agreements? Everybody got a good one? Because I've seen some really bad ones.
All right. We already talked about this, the solicitation rules, when you can solicit, when you can't solicit. We put them in there about advertisements, about written solicitations, and when you can come in. With the, I always try to, because I'm the one who's buying the drinks at the happy hour, I like to put the addiction problems and talk about drinking problems at the end, right before we're going to go down to a bar. Who wants to talk about substance abuse? No one does. No one ever does. No one ever wants to talk about addiction and substance abuse and mental health issues in CLEs or in our legal community. But because we're lawyers and the self-selecting population we are in, we are 2 to 3 times more likely to be drug addicts or commit suicide or have mental health problems. In the ABA study that it's about 2 or 3 years old now, the longer you're in practice, the more likely you are to have addiction or substance abuse problems. And it's an epidemic in our legal profession. It's an epidemic with lawyers and doctors. But doctors handle it better because they are more organized. They have a more organized bar. They're DEA certified, so the federal government looks at them. We have in Missouri, we have MOLAB, and we have the Intervention Committee. Who knows, what do you do if there's a lawyer that you know who has a drinking or drug problem or is depressed? What do you do about it? Does anybody know what to do?
And if so, can you tell us?
No, that's what I'm going to tell you what to do.
Okay.
Now, what if you were at a seminar, you were at a conference too with some amazing statistics about problem drinking among lawyers?
Yeah, I was in Santa Barbara for Litigation Council of America a couple weeks ago, and it was a fabulous conference, and I saw on there they had this thing about attorney alcohol and drug abuse, and so this guy gets up and he says, okay, so what do you think the percentages are for attorneys of different ages and how much they're drinking, this, that, and the other? And so they had done this huge seminar. I don't know if it was the ABA the study, survey. Anyway, it turned out that of your associates out less than 5 years, 70% of them have been drunk in the last month. And drunk meant drinking to the point that they were impaired. 30% of them have been drunk within the last weekend. So the numbers are raising. I don't know why that is. And the numbers for each decade were just really disturbing to me. They also talked about, you put on here, maybe we've already gone past it.
It's 1 in 5.
1 in 5 people in this room probably have some sort of addiction problem. It could be pain medication, it could be illegal drugs, or it could be drinking. And so sometimes I think, because I tend to be kind of a live and let live, until I thought about those 9 young associates I have and what that could do to my law firm. Because what happens is, if you're drunk at work, you're likely not doing the most diligent job you could be doing. And that's a real risk for all of us. And so, you got to ask on one hand, why do we have this problem going? And I think about how we were in law school. It was a drinking culture. It was a really big party culture. Then you get out and you're young and you're single and you're having fun with a group of people at your law firm, and it's still a drinking culture. And then it gets out of control. And so what are our obligations? I don't know. What do you do?
Well, yeah, I'll tell you. So Rule 1601B is one of the best, it's the most direct, amazingly direct written rules in our rule book. It literally, substance abuse causes or contributes to incompetence and malpractice by lawyers and judges. People who are substance abusers neglect clients, violate rules of professional conduct and judicial conduct, and they commit crimes. And they do. And so what do you do? What do you do if it's either you or one of your partners or a lawyer that you see? Don't enable them. Turn them in. What's the downside? MOLAP the numbers in here, it's confidential, it's free, no one will tell anything about it. The Missouri Bar and the Intervention Committee have professional people who will intervene and will help them and know what to do. You don't need to know what the answer is. You don't need to know what the question is, right? You don't need to know how do I reach this person? How do I break through their cycle of addiction and tell them how messed up their out of control, spinning out of thing has caused? You don't need to know what to say, but you need to know to call someone to turn them in, because I guarantee you, if anybody's an active alcoholic or drug user out there, their families are wrecked, their lives are wrecked, they're unhappy, they are stealing money. If you talk to the OCDC people, 70 to 80% of the people who steal money out of their trust funds are comorbid with addiction or drug addiction. Because when you're an active user,
Is that true?
oh yeah, because you take risks. It's always comorbid. There's a diversion program through the ethics rules that if you have a substance abuse, they won't just yank their ticket. They'll do counseling with you. They'll do different stuff. So, and people don't talk about it. No one likes to talk about it. It's uncomfortable. We all like to drink socially. We all may over-drink from time to time. You really don't want to talk about it. But only by and people are afraid to talk about mental health and depression. We have a high-stress job. We're fighting people. We're in litigation. We got to run firms. We got to do 3 jobs. Look at all the pressure we're under all the time. And you need an escape. And there's a line between the escape and letting go of some of the stress in a healthy way versus an unhealthy way. And you know, it's the human condition. We are cavemen. We like to feed this this base human thing with drugs and alcohol, and it happens. So, yeah, in some ways, we're about to go to happy hour. I don't want to kill it, right? But I mean, you know, there's that camaraderie. There's that doing that. But there's also losing control of it and spinning out of control. So and when I do these ethics talks, I like to talk about it a little bit. Probably already over-talked about it, but we have specific rules and specific ways to help handle this and govern our profession. Because the next time is you're going to read about it in the news of the lawyer drunk driving or selling drugs or stealing money from her clients, and it wrecks our reputation. So only by having the courage to do that is helpful and helps our profession.
You know, it's funny, as I sit here thinking, listening to Gary, I thought about my history in the law, and how when we were younger, we would go and be wild and party, and then I think, but everybody calm down. You know, normally calm down after that goes. But I'm representing a client in a case right now where one of the defendants is a person who was drunk on a weekend night, very late at night, pulled up to a stoplight, beside somebody else who was very drunk, and the two of them somehow gave each other the look that they were going to race and act like idiots and killed a woman as a result of it. And the other attorney is an attorney who had an alcohol problem. And I'm fortunate because I can't think of anybody who's had their life ruined that I'm remembering off the top of my head that I was close to, but there are people like that we hear about frequently, many times a year, several times a year, who have problems with alcohol. So if you know somebody, take this page and tell them to call that number and get free help.
If people don't want to call or do anything because they're worried people are going to get in trouble, they're going to lose their license, lose their marriage and all that stuff. It's confidential. There's the number for MOLAP up on the screen. It's confidential. There's an intervention committee. I'm a member of the Supreme Court Intervention Committee. I'm one of 7 in the state. And the intervention committee, and I talk about that, the intervention committee are people that are trained to handle this. It's totally confidential. you can do it. I've had Supreme Court, I've had different judges ask me about stuff. You call the intervention committee people know how to handle it in a quiet way. Then when you don't hear about the success stories.
Yeah.
Because people go on to live their lives and have very successful things.
I
So
didn't even know we had an intervention.
no one does. No one knows about Rule 16.
Before we go past that, I want to point out one thing. It's not just alcohol and drugs.
It's mental
also
health and
stress.
suicide.
Stress and burnout. This is a very high burnout job. We are really lucky and blessed to be able to hold the keys to the courthouse and to represent people when nobody else in this society can do it, but it is an enormous amount of stress. And there are times that are good and times that are bad. And I remember back before I left Evans and Dixon, there was a season where I would leave work every day at 4 o'clock and go home and watch Oprah, just because I was burnt out. And that went away, and I came back to normal, and Oprah helped me get through that, I guess. But anyway, we go through those periods, so don't be ashamed to call and get help.
It's good to be, it's a healthy addiction to be addicted to Oprah.
True,
All right,
that's true.
so keep your IOLTA account, don't mess it up. If you surrender your license, like our former county executive, you got to retake the bar to do it, but you have to get back
That
in.
was shocking. I didn't know you had to retake the bar.
Yeah, we put all the material in there. We're going to be out of time. What do you do if you get an ethics charge against you? You may want to hire an ethics lawyer. You need to question about whether you handle it on your own. You need to look and see what you did and how you did it. You have a time limit to file a written response to the ethics charge. The ethics charge, the allegation will be addressed in the Regional Disciplinary Committee. They can dismiss it, they can issue an admonition, or they can also send it straight up to the Missouri Supreme Court or the investigators for further work. And I do quote Rule 4-8.3 about how the standard that we set up about how do you know whether you should turn someone in for an ethics violation. That's a tough thing. On the one hand, you don't want to be a rat. On the other thing, we need to govern our profession, and we need to make sure that folks aren't breaking ethics rules. I talk in there about the ethics charge, about your response, the complaint, and what to do. And I have a quote about the discipline purpose. Any questions about any of the ethics stuff? And I know we flew and glossed over some quickly, others we got into more depth. Any questions about any of the ethics topics that we touched on?
While you're thinking about questions, I'll remind you of two things. One is the Missouri Bar Ethics Council provides informal opinions. They are fantastic. If you have a question about whether or not something you did was right or wrong, or something somebody else is doing is right or wrong, or something you're thinking about doing is right or wrong, call them, and they are really informative. And the second thing, Gary's last page, which we may not have gotten to, is your trust account. And I heard Alan Pratzel talk a couple years ago on ethics, and the thing that made me most scared was when he said, it doesn't matter who makes a mistake in your trust account, you are liable for it. You are responsible for it. You will be the one whose license is marred because of it. So know what's going on in your trust account. And if you bounce a check or get overdrawn in your trust account, that in and of itself is a violation, and they report it to the bar.
The bank reports it to the bar automatically.
So just be aware of that. I didn't know that. I was scared, went back and did an audit just to make sure. Just kidding.
It is Debbie, it's an absolute joy to do this podcast.
It is.
And do this
It's fun.
CLE with you. It's a lot of fun, so thanks for all your hard work.
Thank you. Let us know if anybody has any ideas about what we can talk about in our podcast.
Yeah, thanks everybody for coming. That's all we got. Happy hour downstairs in the rendezvous.